arbitration for all involved. Thank you.
Thank you, Dr. Tam. I think we have one more person signed up, Annalyn Lagermas. If you don't mind staying for a few more questions. Oh. Yes. Oh, I called you earlier. Please, yes. Was there anyone else who had signed up earlier who intended to testify? Okay. Oh, wait. Turn on the microphone, please. And yeah, thank you. State your name for the record.
All right, thank you very much, Senators Taitagui and Terlahi. My name's Stan Yasuhiro. I'm a dentist here. Been practicing here for over 36 years. It's been a home since 1964. Thank you. Basically it's home. I was very much puzzled about why this arbitration situation it was becoming such a big issue, and in reviewing the way things are being done as far as malpractice or any kind of disagreements, I had to fall back to my experience. I'm a former chairman of the Guam Dental Board. I am also a two-time past president of Guam Dental Society. Over 25 years of international liaison for Guam Dental Society and the World Dental Federations. And so I was able to kind of look at both sides of this situation. And there are things that can be done. There is a lot of talk about arbitration, so I'm not going to even kind of get into the pros and cons of that. But I'm going to kind of bring this down to our local level. From what I'm seeing here, there are a lot of frustrated patients. There are a lot of frustrated people against the healthcare community. And some of it is misunderstanding, and some of it is outright bona fide problem. And I think that the other issue that we have is having proper practitioners on this island. So if we're going to expect proper care on this island, we need people that can practice properly. We need good people. We need good healthcare providers. And in order to do that, we have to have a strong regulatory body, which we don't at this time. And we don't at this time, the HPLO office, the Health Professionals Office. And I don't fault the individuals that are running the office. Actually, I have to give my hats off to them because they are trying to do their best with the very little that they are given. There is no priority given to the HPLO office, which is probably affecting almost everybody on this island. It's one of the most important regulatory bodies on this island. And right now, there are people that are doing their best, trying to work things out, and with all the complaints that are coming in, there's just not enough time, there's just not enough money, there's just not enough energy to get through all this. And they're handling medical, nursing, dental, allied health, they're handling everybody. And this is absolutely just ridiculously kind of cruel, actually. And the support that they need has to come from this body, the legislative body, in the form of a proper budget. There has to be support from the public health office in the way that they need to give them priority. And we have to, as a group, sit down and take them seriously. We've had situations where dentists came on this island seeking to get a license. Sad to say, I have seen cases that were just totally ridiculous. And I don't know why they even attempted to get a license here, but they were told by their recruiters that, oh, you won't have a problem. you'll get a license. And when we failed them, we received a lot of criticism. And there was even an instance where the Guam Board of Licensure was threatened to be disbanded. This was several years ago by a legislature. And so, you know, I think that's the area that we need to work at, because it is the premier regulatory body. Now, in the process of a complaint, we need to go through the hearing process with the hearing officer and the attorneys from the Attorney General's office, as stated and mandated in public law. We should not and cannot have our private attorneys. They have to be appointed through the AG's office. Then, after that is done, then they can go ahead and the parties can accept the recommendations and settle, or they can go ahead and go take it to court. They can go through the arbitration, and perhaps the discussion of coming up with the proper funding for that may help that. But we at this time, our hearing process, in my opinion, my personal opinion at this time, I think is broken. And I think that needs to be fixed. So, you know, people such as Mr. Lubofsky and his family have a way of getting some type of resolution from this tragedy. And so I think that we need to kind of work with the system that we have right now and fix it. And so I'm not going to go into detail at this point, but if you'd like, I'd be happy to make any input on that. Thank you.
Dr. Yasuhiro, you are a breath of fresh air, and I want to thank you and it's very timely, because I do think there's been just very recently a new focus on the HPLO, the licensing office for all the all the healing arts, for all the medical, the nursing, and the allied health, all of it, and exactly what you've pointed out. So. And that was also one of Mr. Lubofsky's initial complaints, was that his initial complaint was not handled quickly, and some of the Allied Board complaints are not yet handled. But so the good news is that, yes, new focus on it. I want to thank the Director of Public Health that she has prioritized this. They have dedicated already, sent out RFPs, and for some of these things, they have to renew the hearing process. So. Hearing officer from the Attorney General, prosecutor hired by the boards or the HPLO office. They're going to hire investigator and an inspector for all the boards to share at this point. They are making they have a renewed interest in their funds, obviously, in order to fund all of this. So you might be in your respective professions seeing some requests for increased fees. They're going to look at fees and the funds. And I have promised to make sure that the original intent of the statute, where all the fees for your field go to the board for that field and are utilized for regulation as it was intended. And I think the regulation is what you're describing. This, we have strict criteria, and we need to enforce that.
I just wanted to mention right now that all the funds are going to the public fund.
Right, that's the
general
complaint.
fund.
So that's what I'm saying. It's they're supposed to be allocated to the boards, and we're going to ensure that that is happening. So, so that everybody can be satisfied that the fees you are paying are actually used for the purpose of regulating your field as they're supposed to be, and that the patients can be satisfied that they are going to get that due process, or that process that they've been asking for. And so you're correct. There is a big disconnect in that area at this moment, but thank you for that. All right, thank you very much. All right, I had a couple questions. So on your proposal, well, Mr. Lubofsky, one of your alternate proposals, now not the original proposal to repeal the entire statute, but in one of your alternates, you discussed extending the the time period in which to file, up to 3 years. Right now, it's 1 year in some cases, and up to 3 years. And did anyone else have anything to say about that proposal? The 1 year is a little bit problematic because if you go through arbitration and it takes a while, that 1 year is your deadline to also file in court. So I think what you're looking for is a way to also file in court, have some time after the arbitration to decide whether you're going to continue in court or not.
Also, in most states that I looked at, it was 3 years. And during the first year, there were some things that I discovered, or that we discovered, wasn't towards the end of the first year that impacted our own case. It took about a year to try to get information. So first year, through everything that you're going through, things come up. So for sure, 3 years, and that's what most states have, from what I understand, is 3 years to file. And I think it's fair. Why not? And sometimes, if somebody's injured in the first year, the ramifications of that injury is not really known until the second year. They've been injured, they don't do anything, and finally they find out, oh, you have this serious problem, but the 1 year's already passed. So it allows time for the ramifications of an injury to be defined.
Thank you. All right, and then the proposal to have a fund that will help patients who want to make a claim or go through arbitration to be able to afford those initial costs of arbitration, and that the fund would be reimbursed if the patient is successful and receives an award in arbitration, and they would reimburse that fund. All right. Mr. Keogh, did you want to say anything regarding any of these proposals? There were other proposals that are on the table. If I could just read them, there's a short list. So those are a couple. One was to, of course, one suggestion was to make sure that we don't have to use one single provider for arbitration, the AAA, and that we can have many alternatives, or any alternatives that the party can decide. Less expensive alternatives was, I guess, the goal, right? So instead of a 3-panel, perhaps a 1-panel. Those were some of the suggestions. To be able to get arbitrators that might be less expensive from different areas. That was another suggestion. The assistance fund. When the suggestion is made to repeal arbitration altogether, there were also some other suggestions that if you repeal arbitration, put something else in its place. And this is what we've seen in other jurisdictions. Not always very satisfactory either, because in some of those we have a screening panel, so that's a proposal that's on the table. A screening panel where they are going to screen the merits of the case, and then you go to court, or a caps on damages is kind of the trade-off that we've seen in some other jurisdictions, where they repeal or they don't, you can go straight to court, but they're going to cap what you're going to be able to receive. Changes in the statute of limits is also on this list. A more transparent claims process, and I'm hoping to solve that issue through this HPLO board, that complaints to the boards are dealt with efficiently, and we can't, well, I'm not sure. I haven't heard exactly a proposal of how to make an arbitration process transparent, to show the parties, but still, that's possible, I guess. Island peer review of claims. I think this is kind of what these boards were set up to do. We have boards for each field that's supposed to be comprised of members of your field, and they're supposed to be the ones who are reviewing claims at that level, at least. And then there was some ideas for caps on the government claims. So these are claims against government physicians. And that there's also been a suggestion that the claims against doctors practicing at the